Hello and welcome to World Talks on TVP World with me, Hashim Kumar. Poland's judicial crisis has taken another dramatic turn. The Court of Justice of the European Union ruled that Polish courts must disregard judgments issued by the Supreme Court's extraordinary Supervisory Chamber, declaring it does not meet EU standards of independence and impartiality. This ruling deepens the chaos surrounding Poland's judiciary, raising profound questions about the rule of law, legal certainty, and the impact on businesses and citizens. Joining us is Professor Artur Nowak-Far, legal scholar at the Warsaw School of Economics, to lay it all out for us. Professor, welcome back to TVP World, and thank you for taking the time.
Thank you for inviting me.
Pleasure as always, sir. So what's this all about? What's the dispute about, in very simple terms?
Well, the dispute is about the quality of the chamber you've mentioned and its ability to provide any judgments, any binding judgments with regard to matters which may involve or which have involved or which involve the European Union law.
So what do they mean when they say that this chamber is not impartial? It's not impartial. What does that mean? Impartial compared to what? How do they decide that?
Well, it means actually that if it is impartial, if it is politicized, because that is the part of the reasoning why it is impartial, well, it's not really a court under the European Union law. And a part of complexity here is that whenever that chamber rules over any matter which is not well governed by the European Union law, it's still a court according to the purely national Polish law. And in order to judge the mass or the complexity, you have to realize how much European Union law is important to the Polish legal system. And that means that this part of the judicial system, national judicial system, is not considered or should not be considered by any other real court to be the court of law.
But this chamber is part of the Supreme Court, isn't it? And therefore should carry the same level of authority as the Supreme Court. Why doesn't it?
Well, because it lacks independence. Well, it means that since we have in the European Union certain standards which we expect the courts to meet, that court or that part of the Supreme Court, the chamber, the people who sit in that chamber do not provide that required merit, and the judgments are only opinions whenever those judgments refer to the European Union law. If it is not referring to those judgments, if they are not referring to the European Union law, they should still be considered the judgment of the court of law.
Understood. So what kinds of actions does that chamber hear?
Well, it hears quite important judgments, matters, because it's a disciplinary chamber. So whenever the judge misses the merits which are required of the judges in Poland, well, that person has a standing eventually in that before the chamber. Also, the chamber, interestingly, is invested with the prerogative or with the power to accept and control before the acceptance of the quality of the parliamentary and presidential elections.
Okay, so does this ruling by the European Court actually apply retrospectively to decisions made by the Chamber, or does it only apply to decisions going forward which conflict with EU law?
Well, it's retroactive because, as a general rule, all the judgments of the Court of Law of the European Union are retroactive. They pertain to the situation which has emerged in its original fashion, in its original moment. Only when the European Court wants to somehow maneuver with it, it will specifically indicate it. I have not seen that element of like undermining the retroactivity of that judgment in that very judgment.
So does that mean that all decisions made by this chamber which conflict with EU law to date simply aren't valid any longer?
Well, Redactor, even if they are not in breach of the European Union law, they are not valid. The quality of the judgment of this chamber does not matter. It is quite important that this court does not have any quality, any merit to give a judgment pertaining to the European Union law. And also, quite importantly, it does not have the quality to pose any questions or to communicate with the European Court of Justice.
Okay, so what does that mean if you're a citizen, for example, and a decision from this chamber has been passed down which affects you, but now the European Court says, well, sorry, that's not a valid decision anymore. What do I do as a citizen?
Well, whenever you are unhappy with the judgment, and I suppose many people would be unhappy with the judgment, and whenever you have you can establish a link between your judgment and the European Union law, then you may ask any court or even any state authority to simply ignore the judgment, disregard that judgment, and disapply this judgment. If that judgment has been applied for any reasons, then I suppose you have a path paved currently to seek any redress of the wrong which has been caused as a result of that judgment.
So if you've suffered a loss as a result of the judgment, you should be able to claim some kind of compensation for that loss.
Right. But only whenever you can establish a link with the European Union law. If that judgment pertains only to the situation which is purely natural with the national law applicable, then, nothing really happens as a result
the original
of
judgment stands.
Judgment.
Yeah, the original, understood.
Yeah, absolutely.
But here's the thing, as a citizen, having to go through all the cost and expense of trying to reverse the original judgment might be prohibitive, and citizens will say, I simply can't afford to do it, even though it no longer has legal standing. What then?
Yeah, that's the weakness of almost every judiciary system in the world, unfortunately.
What about companies, Professor? What does it affect companies in the same way as it affects citizens?
Absolutely. And may I also draw your attention to the fact that this judgment was really the judgment about the companies and about the economic law which pertains to the companies. Absolutely, that judgment would uh, uh, produce many effects for the companies, because European Union law is predominantly economic.
You see, because the thing that strikes me is that, if you're a company investing in Poland, and a judgment has been passed in your favour or against you, and then this conflict is highlighted by the European Court, you're the one that's at risk, and it basically, you'd think twice before investing in Poland. In other words, there's a long-term economic knock-on effect, isn't there?
Yes, you're absolutely right. It's rather discouraging, rather, well, disappointing for those who invested in Poland. And it should not happen. We also talk about this situation with this chamber, that this quality of this chamber, this merit of this chamber is to some extent, or to a great extent, contagious to the legal system or judiciary system. And it should not be like that anymore.
Understood. So, going forward now, what can be done to prevent a situation like this, not only in this chamber, but in other courts? Because clearly there's a huge amount of confusion caused by this.
Well, in a way, it is quite simple, because whenever a court, or whenever any state authority has a problem which involves the European Union law, it now has a full right to disignore the chamber. And if I were that authority, I would. The power of attorney for that authority, I would then go to other chambers of the Supreme Court if I had the reason to do that.
Understood. Professor, unfortunately, we're going to have to end it there, but thank you, as always, for sharing your analysis with our audience. Have a good evening, sir.
The same to you. Thank you.
Bye-bye. And that brings us to the end of this episode of World Talks. Don't go away, though. Lots more still coming up. Goodbye.